for the good stuff, and I'll work through the introduction while people are joining, some of the late stragglers. So I want to welcome the folks attending to SCORE Massachusetts webinar, and the topic is, excuse me, what small businesses need to know when considering bankruptcy. And our presentation today will be given by David Berman, and he's a SCORE counselor with the Boston chapter, as am I, Donald Whitmore. And I just want to give a quick introduction as to SCORE Boston and the type of services we provide. And we're all volunteers. We're trying to give back to the community, and we have a variety of backgrounds. And the nice thing, it's free and confidential mentoring. We do it for the joy of giving back to our community and working with folks like yourself. And for now, due to the pandemic, we're doing video, phone, and email. Generally speaking, we have client interactions at our main site, which is in the Tip O'Neill Federal Building, but there are satellite offices as well, distributed around the excuse me, Metro West Boston area, in which we can meet you as well. As I mentioned, it's a wide range of expertise and experience. There are folks at the SCORE Boston chapter who have successfully started their own companies. Many have been entrepreneurial, if you will, inside companies, and everything in between, both men and women in a variety of industries. And the nice thing is we encourage you to meet with different mentors, and we're not offended at all if you want to get a different perspective on your situation. So that's a really great benefit, I think, to the folks that are able to take advantage of that, is to reach out to different mentors. The nice thing as well is, like this one, we have a variety of workshops and webinars offered in the Boston area. There's an email list. I believe when you attend this session, you should be added to it. So you should get notification of a variety of different webinars and workshops available to you. And certainly that information will be available to you on the SCORE Boston website as well. And if there's a need to expand outside of our chapter, we're more than happy to facilitate that, and that's something we can work with you on as well. SCORE Boston is just one of many chapters throughout the country, and we're happy to work with you to reach out to other volunteers. As I noted, mentoring virtually during the pandemic, video, phone, and email. Certainly meeting in person is always best, I think, to get a good interaction. But given the situation now, we are leveraging the video, phone, and email. And the one thing that we recommend is that if you have a mentor and you've met with them and maybe there was a lapse in time of meeting with them, it's nice to have an update, just to touch base with us and yourself to see if we can't help you, and just use us as a sounding board of some issues that you might have. If you don't have a mentor, there's a find a mentor functionality. There are links here listed, the variety of SCORE websites. As I mentioned, there are other chapters, the Worcester chapter, Western Mass, SEMA, New England, Massachusetts. Ours is Boston SCORE, and then Cape Cod SCORE as well. So in terms of this webinar, David and I have chatted briefly about how to facilitate questions. We'd like to have an engaged and interactive discussion with you all. So if you would like to pose a question, I ask that you just type it through the Q&A functionality for the menu up top, or it might be at the bottom of your screen there. I'll show on the next slide, I'll point that out. And we'll address questions as they come if they're relevant at the end of each slide, and I'll defer to David if he wants to address them, or maybe a subsequent slide might address that question. But we'll do our best to answer your questions, and certainly we can address some offline as well. The one thing we really would appreciate you doing at the end of the presentation, just to get feedback from you, just to make sure we're doing a good job and the topic was relevant, and to address any issues you might have. There's going to be a brief survey. So we ask if you could just take the time, it would help us out, just make sure we're on point and delivering what we hope is a great presentation. Certainly, David has a great background. I'm looking forward to learning along with you. And as I mentioned, the Zoom how-to, if you see the slide here, it points out using the Q&A for asking questions. If you do have comments, you can use the chat function as well. I'll be monitoring that during the presentation, and I will pass questions or comments along to David as we continue the presentation. And with that, I would like to introduce David, and excited to have this presentation by him, given his experience as a partner in private practice law firm for over 40 years, focused on general business issues with significant experience in the retail industry. And this experience includes representations of clients in connection with commercial financing transactions, mergers and acquisitions, financial and business restructurings, commercial bankruptcy, reorganizations and liquidations, commercial real estate acquisitions and commercial leases, contract negotiations, and entity formation and governance. And with that, I will hand over the reins to David. And thank you so much, David, for taking the time to give this presentation this morning.
Okay. I'm going to share my screen before we start. So, all right, you have to unshare, I guess. Now I can start to share. Okay. Good morning, everybody. Thank you for taking the time to join us this morning. It's been a very busy time for bankruptcies in light of COVID, and we thought we'd share a little information that may be helpful to you in considering the approach for your own businesses if necessary. And I say if necessary because bankruptcy should be the last option. Bankruptcy can be an expensive process. You also can have lots of other decision makers in there trying to influence the direction of your business, whether it be the court and other creditors. And so you can lose a little bit of control. So, you know, if you can identify your problem and try to negotiate around it with your landlord, with your trade creditors, or whatever it may be, and do an out-of-court resolution, that is going to be a preferable start rather than filing bankruptcy, because a large number of companies that file bankruptcy thinking they're going to just restructure, reorganize, and come out and operate again, never make it out of bankruptcy and are liquidated. So I would encourage everybody to, depending on what the issues are, to try to work it out outside of bankruptcy. But that being said, if bankruptcy is an option, it doesn't just start on day one and you say, I'm going to file bankruptcy. There's a lot of planning that goes into the bankruptcy, and this can take weeks, depending upon the complexity of the case. You know, it's such a specified area. The first thing you should do is to find a bankruptcy practitioner, and they can help guide you through this. And it's not just a lawyer, but you may want a business consultant or an accountant on board to work with the numbers. You may, if you're trying to dispose of the business or dispose of certain particular assets, you may want to engage an appraiser. But you put a team together consisting of your lawyer, accountants, consultants, appraisers, whoever is necessary for what your goal is. And you should try to determine what your goal is going to be by the bankruptcy. Are you looking to get out of some leases? Are you looking to restructure your debt, term out some debt, or reduce your debt? Are you looking to sell the business? You should formulate a plan, and of course, plans are flexible. You don't have to follow it all the way through, but at least when you go in, you should think about what you want. And a key part of this process is preparing a cash flow reflecting the bankruptcy impact. I will say that the bankruptcy courts are very concerned with the company being cash flow break even during the bankruptcy. You know, the problems you have before the bankruptcy, that's why you're in bankruptcy. But during the bankruptcy, the court's going to see the landlord's paid, the trade creditor is paid, your employees paid, and so on and so forth. So it's important that you prepare a cash flow reflecting the bankruptcy impact. And some of these impacts I've listed below in no particular order. First, your vendors. You may have had 30-day terms before the bankruptcy. Your vendors may want to get cash in advance, cash before delivery, cash on delivery. You may not get the same terms for payment. And so that has to be factored into your cash flow to the extent you need to buy goods and need these to operate your business. Financing, we'll talk about this in more detail at a later date, but if you have a bank line of credit, for example, once you file bankruptcy, the bank is not obligated to provide any more loans to you. So if you're going to need financing to operate the business during the bankruptcy, you need to be negotiating with your lender or find a new lender to provide that financing in the bankruptcy. Obviously, if you just have a term loan that you use to buy some equipment, you're not looking for more money there. But if you're talking about working capital financing, you need to negotiate a new deal with your lenders or find some other source of financing during the bankruptcy. As I said, we'll talk about that a little more detail later. Employees are key to the business as well, and employees sometimes get spooked by bankruptcy and concerned that they're going to lose their job. So at the appropriate time, you need to sit down with your employees and keep them calm, keep them employed. In certain bankruptcies, under certain circumstances, you can offer and the court will approve a stay bonus, which basically is if the employee stays throughout the case and doesn't leave the employment, he or she will get a bonus at some point in time. That's one incentive that sometimes is used to keep key employees. But, and I wouldn't recommend going to the employees at the early outset, but as you get closer, it's important that you keep them informed, especially the key people that you want to keep on board. Utilities also, they cannot stop providing service to you, but they are entitled to a security deposit, whether it be in cash or a letter of credit. And the amount of the deposit, could be 2 months, could be more or less, depending upon what your history is with them and how they feel. So that has to be built into the cash flow. Also, we talked about engaging professionals. They'll probably want to be paid on a monthly basis. You need to build in something for payment of the professionals as well. Now, you're not going to need to pay debts that existed prior to the filing. I mean, you may have to pay interest on a bank loan that's secured by property, but you're not going to have to pay your trade and past due rent you won't have to pay. You'll have to keep rent current during the bankruptcy, but so all of these factors will be included in your cash flow. The timing of filing is an important consideration as well. If your landlord has terminated the lease, you have nothing to protect in the bankruptcy if you're looking to operate from that location. So you would want to file a bankruptcy if you're in default of your lease before the landlord terminates it. That way, the lease is preserved. You can operate from the premises as long as you pay the post-petition rent. And but if it's been terminated, there's nothing for the court to protect, and you'll be subject to eviction in normal time, shall we say. Also, some retailers like to file, just before the Christmas season. Christmas usually is the time when you're cash flow positive. You get a lot of cash flow in, so they like to have the pile of cash to operate with in the bankruptcy, as opposed to filing at a time when you're not going to have a lot of cash coming in. You'll also have to work with your attorneys to prepare schedules and statement of affairs to be filed with the court. Those are basically schedules of all of your assets and liabilities, listing all the creditors, how much they're owed, whether you contest the claim or not. And a statement of affairs asks a bunch of questions about, past business operations to see if, among other things, you've been paying your taxes, you've paid preferential creditors, and so on and so forth. And then there's the first day motions. As I said at the outset, you don't necessarily have the right to do what you want in a bankruptcy. A lot needs court approval. And so therefore, when you file a bankruptcy proceeding, you need to go to the court on the first day and get the court to approve various things that you want to have done. For example, you'll want to file a motion to improve the engagement of whoever your professionals are. Now, the court will probably allow that on an interim basis on the first day, but won't necessarily agree to it on a permanent basis until the creditors have a chance to review the professionals' applications, their conflicts of interest, and so on and so forth. Beyond that, if you're in the retail business and you have gift cards, you can't honor those gift cards without court approval. And that court approval, most retailers find, is very important, because to maintain the goodwill of the customers, they want to have the customers be able to come in and do business as usual. So you would want your gift cards approved. If they're not approved, you can't honor them, and there'll be a pre-petition debt. Another key first day order is relating to the payment of your employees. If you have a weekly payment period and the employees get paid on Friday of every week, and you file a bankruptcy on Wednesday, unless you get court approval, they would not be entitled to get their pay for Monday and Tuesday when you pay them on Friday, because it will be a pre-petition debt. Obviously, not where you want to be with your employees. You want them to be very happy with you, so you go on the first day and you seek court approval to pay them for their pre-petition wages. There are some dollar limitations on that, but in general, most of your employees will fall within the dollar limitations, and you can get them paid for any pre-petition services that they've rendered. Similarly, on your taxes, you would like to pay your sales taxes, if they're sales taxes or other taxes, as they come due. But for the pre-petition periods, you cannot pay them unless you get court orders. So you try to get a court order allowing you to pay your taxes at the designated times when they come due, regardless of whether they arose before or after the bankruptcy filing. And you can, if you have a lot of old income taxes, those you may defer into your plan, but you'll want to pay your FICA contributions, your sales taxes, and the like, whether or not they arose before or after the filing of the bankruptcy. Another thing that you have to be prepared for on the first day is typically the bankruptcy court requires you to go set up new bank accounts, because any checks on your old accounts should be bounced because they were pre-petition checks. And with some borrowers or some companies, they have lock boxes in which all their checks are sent, their receivable checks are sent. And so they want to maintain the existing accounts, and to do that, you have to ask the court for permission. And your checks, for example, are supposed to say XYZ company debtor in possession if you're in Chapter 11. And you may not get those checks right away, so you still want to use your old checks. I mean, this is really important for a major retailer such, let's say, Neiman Marcus, which has bank accounts all across the country that feed into one master account, and they don't want to have to go and set up all these additional accounts. So on the first day, they would try to get a court order authorizing them to maintain their existing accounts and directing their banks to honor checks that are presented on or after a certain date. Obviously, the checks for pre-petition, the banks would still return, but you'll want to keep up the same bank account systems. Other thing that's very important on first day is if you need working capital financing or any financing, you should try to get that approved on the first day. Otherwise, you could be waiting 2 or 3 weeks without financing. The court typically will allow some sort of financing to cover your needs for the first few weeks of the case, and then you'll come back for a fuller hearing on continued financing. But the bottom line is you need to be prepared on the first day if you need financing to go in and get court approval for that. Also we talked about utilities. You want to get them straightened away on the first day as well. So those are just some of the things, but as you can see, before you even file, you need to do a lot of planning and get a lot of ducks in order so that you can go in and operate business as much as usual as you can. Now, the benefit of the bankruptcy is once you file the bankruptcy, there is a stay. None of your creditors can sue you on your old debt. Your landlord can't move to evict you for past due rent. Everything is stayed in place to give you an opportunity to reorganize and come up with a plan to deal with your problems. Now, 2 things to be noticed about the automatic stay is, one, if you guarantee a debt like a lease or a bank line, the stay doesn't apply to the creditor pursuing the guarantor, because the guarantor is not in a bankruptcy. So as you're thinking about this, you could ask the court to stay the pursuit of the guarantees. That's possible in some cases, not generally available. Or you need to negotiate with the creditors to hold off on pursuing the personal guarantees. Or thirdly, if the creditors won't and you can't hold them off, you may need to file your own personal bankruptcy. The other thing that the automatic stay doesn't stop is governmental enforcement action. So for example, if you're operating a service station and you're just taking the gasoline and putting it in containers and spilling it into the environment, that's not stayed. The government can come and exercise its police powers to make sure you're operating in accordance with applicable regulations and laws and licenses. If you have like a liquor license, they can make sure that you're operating in accordance with the license. So the stay is a good thing. It generally gives you enough breathing room to come up with a plan. Now, there are reasons that a creditor can go to the court and terminate the stay. First one is for cause, and we'll talk about this a little bit later when we talk about adequate protection. But if there's cause that the creditor is being harmed by the stay, they could seek court approval to obtain relief of the stay. If there's no equity in an asset and it's not necessary for reorganization, let me give you an example of that. Let's assume you have a manufacturing business and you finance the acquisition of a piece of equipment for a particular line that you were running. And if your plan is to terminate that line and just work on your other core business, and the equipment value is less than the amount of the claim, you would have no equity in that particular piece of equipment. You wouldn't be using that to reorganize your company. The creditor could come in and ask the court to release the the stay so that you can come in and take the piece of equipment and realize upon it. Most of your assets will be necessary for a reorganization. You may not have equity in them if they're oversecured, but you may still need it for reorganization. So the fact that there's no equity in it for you isn't the sole test. It has to be both no equity and not necessary for reorganization. I also added in here in a single asset real estate case. So landlords are being hurt right now by COVID, and there are certain landlords that just own one piece of real estate, and because they're not getting rent, they'll file. And if the landlord doesn't put together a reasonable plan of reorganization, it doesn't have to be approved, but just has to be not pie in the sky in 90 days and begin paying non-default interest, then the mortgage holder could come in and seek relief from the state of foreclose. But you can see there still is a 90-day window for the real estate owner to come in and come up with a plan to stop the foreclosure. All right, we talked about the operation of the business. Utilities, we've already alluded to the fact that cannot stop service because you haven't paid your pre-petition utility charges, and within 20 days, you have to give them some security, as we talked about, and oftentimes we try to get that resolved on a temporary basis on the first day so that you don't have to worry about utility operations. Other limitations on your operation of your business: you need court approval for sale of your assets other than in the ordinary course. So if you're a retailer selling your inventory, that's okay. But if you're that manufacturer that has that piece of equipment you don't need anymore, you need court approval to sell it because you're not in the business of selling that piece of machinery. Similarly, if you have a piece of real estate you want to sell, or if you want to sell the business as a whole, you need to go to the court to get approval. And depending upon the size and nature of your business, the court may have you set up a bidding procedure in which you notify potential bidders of a date for an auction. You go to the auction and it's conducted like an auction. The high bid usually wins, but you still need to go get that high bid approved by the court. A lot of businesses are sold through this process. A lot of leases have been sold through this process. But there is a process, a cost, and a time delay involved with non-ordinary course sales, potentially. Also, if you're selling your customer list, I was talking to somebody who was thinking of going out of business and said they had no assets. And I said, what about your customer list? In a bankruptcy, you can sell a customer list, but you have to sell it in accordance with your privacy policies and applicable governmental privacy policies. And the court will oftentimes appoint an ombudsman who will review the sale and make sure that the customer's privacy and the terms of the sale of the customer list are in accordance with your procedures and applicable law. So, you can see already that, there can be significant limitations on your ability just to run the business the way you want to run the business. And as we get to financing options, you'll see that even more so. As I said earlier, if a bank has a line of credit with you when you file a bankruptcy, the bank doesn't have to continue to provide credit to you. So you have various options under the bankruptcy code. One is you can get unsecured credit with administrative priority. And the concept of that is that the lender would be an unsecured creditor, but would be entitled to priority of payment if you went to liquidation. So in other words, post-petition, you have your post-petition professional fees, you have your post-petition vendors, your post-petition landlords. the financier can sometimes obtain priority over all of those in the event of a liquidation. I will say that my experience is that it's very hard to get unsecured credit with administrative priority. So now you have to go to step two, which is securing the loan with a junior lien or a lien on unencumbered assets. So let's assume you have a piece of real estate that has a first mortgage but has equity in it. You could give a second mortgage to somebody if they'll give you money on that. Similarly, on your equipment or inventory, any asset that you have that's secured by a first lien, you can obtain a second lien on and get funds that way. Again, that's not always an easy sell. The easier sell would be a lien on an unencumbered asset. So if you had a piece of real estate free and clear, you could give a first lien on that to get the financing, or in some cases, giving liens on intellectual property, patents, copyrights, trademarks. You can get some funds that way if they're otherwise unencumbered. The third way is to get a priming or co-equal lien. So let's assume that you have a lien to a bank, first lien secured by all of your business assets, and the bank doesn't want to give you money anymore. Then you could go out and get another lender to come in and say, I want a first lien and we're going to push this bank down to a second lien. And that can be done as long as the bank that's being pushed down receives what's known as adequate protection. And the concept of adequate protection is that that bank should be in no worse position at the end of the day than it was pre-petition. So that if the bank was owed 100 and your assets were worth 250, the bank is fully secured. So at the end of the day, it has to remain fully secured. That doesn't mean they have to maintain the 150 collateral cushion, though. They just have to remain fully secured. So in this example, if you went to another bank and said, I want a $75,000 loan secured by a first lien, and the $100,000 creditor will push down, it would still only be $175,000 against $250,000, so the creditor would be in no worse position from the court's point of view. So any creditor who has a lien on your assets is entitled to adequate protection. And the whole concept, as I said, is to keep them in the same position they were. You can give them adequate protection by making payments to them. You can say, all right, I'm going to pay you, I'll pay your interest on your debt, and I'll pay you some principal, or I won't pay you some principal, but you're still secured by your lien, so I'll pay interest so your debt doesn't get higher. You could give them a post-petition lien, and this is a very interesting concept because under the bankruptcy code, if you have given a lender a lien on your assets, your inventory, your receivables, when you file bankruptcy, that lien only attaches to that inventory and receivables that existed on the day of the bankruptcy filing, and whatever proceeds come from those assets. So that if tomorrow you went out and you bought $1 million of new inventory, or you created $500,000 of new receivables, that wouldn't be subject to the pre-petition lender's lien. So what the pre-petition lenders usually ask for, and I would say most often receive, is what's called a rollover lien or post-petition lien on those new receivables and inventory. They typically, if they only have receivables and inventory, they typically wouldn't get a post-petition lien on new equipment or new IP or new real estate you acquired. It would be limited to the same type of collateral. Although as adequate protection, you could offer them a lien on collateral that they didn't have before. But that's another way of giving them adequate protection, because the court's going to say, for example, in my proposal, that, as you collect the receivables, if they don't have a lien on the new receivables, then you're going to, use their cash and there's nothing left for them. So by giving them a lien on new receivables, they would end up still having a lien and still be protected. The indubitable equivalent is anything else you can think of that makes them happy. Sometimes you put up a letter of credit, sometimes you give them a personal guarantee. They're just, use your imagination, and if the court finds that they're getting value that's going to protect them, they will allow that. So adequate protection is very important, especially if you're trying to prime and jump over them in terms of lien priority. But you'll see the last bullet point in financing options is use cash collateral. So if you don't think that you need a loan and you can just live on your cash flow, you can do that. Now, if there's a lender secured by your assets, once again, you're diminishing their cash as you use it in the operation of your business. So you would have to provide adequate protection for any diminution in the value of its collateral. So, if you can operate on cash flow and you have a lender that's a 100,000 lien on your assets, you can give them a post-petition lien. You can make payments to them. Whatever you can work out in order to use your cash and live on your cash. That's why I say the timing of filing could be important, because if you're filing during the holiday season, if you're a retailer and lots of cash is coming in, you probably could live on cash for a while at least. I would say that from experience, when you're negotiating these financing options with a lender, they'll want to throw lots of other things in. For example, they'll want you to file a plan of reorganization by a date certain, or they'll want you to dispose of certain assets by a date certain. They'll put all sorts of conditions in the lending document in order to make sure the case is progressing. But the key thing is, obviously, whatever you agree to here has to be approved by the court. Whether you're using the cash, whether you're securing the lender with a lien, you need to go get court approval. And as you'll see, there are more people that will be heard in these proceedings than just the court and you.
David, may I ask a question?
Sure.
Yeah. What I found with small businesses, sometimes they because they're mom and pop shops, they might leverage family connections as a loan, and what happens is there's sort of the danger of the preferential repayment in terms of priority of those loans. Do you have any thoughts on if you were to reach out to a colleague or a family member to help prop up your business around the time of a bankruptcy proceeding, the dangers or the pros and cons of that?
Sure. We'll talk about preferential payments in a little bit, but in terms of family money coming in or friends money coming in, I would recommend that you give them a lien on your assets, first of all. And that giving them the lien on the assets just puts them ahead of other creditors. And it shouldn't be preferential because they're giving you new money. One defense to preference is that you receive new value. And so if somebody's giving you $50,000 and taking a lien on your assets, that's not going to be preferential. If you yourself are putting money in as the owner of the business, you could approach it the same way. Creditors may argue, though, that the money you're putting in is just additional equity capital and not really a loan. But I'd rather have that fight with you having put the money in and taking a lien for the new money that you're putting in. But as I said, when it's the equity owner putting it in, the creditors may think that it's just that you were undercapitalized to begin with, and this should be treated as capital rather than a loan. But I have no problem with family money coming in. I would just secure it, and even in a bankruptcy, when we talk about getting financing, it doesn't have to be from a bank. You could go get it from family. you can do that and get the court to approve it.
Thank you.
Leases. Leases and executory contracts. An executory contract is a contract where there's still things to be performed on both sides. So for example, if you're doing construction of your leased space and the contract's in the middle and it hasn't been completed, that's an executory contract, that because the contractor has to finish the work and you still have to pay him for the work to be done. So they're treated similarly, not the same, but similarly as leases. As I said, when you file a bankruptcy, you do not have to pay for pre-petition rent. What you do need to do, though, is pay the landlord as you go going forward. Now, I won't get into too many details, but some jurisdictions would say that if you filed on March 15th, you only have to pay for March 16th through 31st. And others would say if you pay on March 15th, you don't have to pay again until April 1st because the lease payment date is the first of the month. Depending on what jurisdiction you file in, you may get some extra rent grace that you otherwise wouldn't. But in general, you should assume that you have to pay the lease during the bankruptcy. Now, if you want to assume the lease, which means you want to keep the lease in place, or if you want to reject the lease, which means you want to get rid of the lease, you have 120 days after filing with a 90-day extension, which you can get unless the landlord consents to a longer period. So this was a big problem for big box retailers because let's just use the example of JCPenney. When they file bankruptcy and they say that they're going to close a lot of stores, what would happen is those stores, they would do going out of business sales. I mean, one's going on right now downtown at Prudential, Lord and Taylor. And they need to get out of those stores, pay rent during the sale, but if the sale is going to go more than 120 days, or the extension period, they were having problems reorganizing because they'd have to make a decision on which leases they wanted to keep before they had to file their plan of reorganization. So that resulted in a lot of companies basically being liquidated because they didn't have enough plan time to decide when to accept or reject the leases. So they were forced by their lenders to start a liquidation sale before the 120-day period. But in general, for a small business, you have 120 days with the possibility of another 90 days to decide, do I want to keep this lease or do I want to get rid of the lease? Until you get rid of the lease by rejecting it, you have to keep paying the rent. If you assume the lease, then the lease goes forward as if you had never filed bankruptcy. Creditors generally like to have some say on assumption of lease except as part of a plan, because if you assume the lease, it becomes a post-petition debt, which is an administrative claim and would have priority over pre-petition claims and would therefore impact the amount that unsecured creditors would get in the event of a liquidation. So they like to see the assumption being in connection with a plan of reorganization as opposed to prior to that because of the potential for them being so-called primed. For other executory contracts, the construction contract, the court will set a time if the contractor keeps working, that's fine. But if the contractor may want to know, are you going to keep my contract or not keep my contract? They'll go to court and say, court, please make a decision by a date certain, and the court will generally set a time period for you to make a decision so the contractor is not held in limbo. But, leases are really the key, I think, for small businesses, and making a decision on whether you're going to stay in that location, move to a new location, is an important decision to decide sometimes even before you file. Now, I would mention in connection with leases that some leases have value. In my practice, we sold a lot of leases because the lease was at $1 a square foot when the current market was $10 a square foot. And so somebody was willing to pay for that good lease rate. And once again, as I said, we talked about auctions and the sale. We would auction those leases off, and people would come in and pay good money to get the lease at the below market rate for the remainder of the term. Now, as part of that, you would have to assume the lease. You have a buyer, the buyer wants to take the lease on, you'd have to assume the lease. So assumption would require you to cure the defaults. So if you're 3 months in arrears, you'd have to bring it current. You compensate for pecuniary losses, which, maybe you have to pay some legal fees or whatever, and adequate assurance of future performance. So the landlord is entitled to know that whoever is going to be making payments on the lease is going to be able to make the lease payments. So if you're the small business in the bankruptcy, the landlord's going to want to see your cash flow and your plan to show that you are going to be able to make these payments, and it's not just something that's going to fall apart in 2 months. Similarly, if you're selling the lease to a third party because there's value in the lease, third party has to come in and show that it can make the payments. And sometimes they have to show financials. Sometimes if they're a big company, the landlord just says that's fine. But the landlord is entitled to know that this assumption is not going to be followed immediately by another default. If you're in a shopping center and you're trying to assume the lease or sell the lease to somebody, you still have to comply with shopping center restrictions. For instance, if the shopping center says you can't operate a pharmacy because they have a CVS in there, you can't sell it to Walgreens and have Walgreens come in. And so whatever restrictions apply in shopping center situations would have to be complied with too, and may limit some buyers. Now, what happens if your landlord goes bankrupt and decides he's not going to honor your lease? Well, you can stay in there for the rest of the term and pay your rent. And you get to offset against your rent costs for you to perform the landlord's obligations. For example, if the landlord has the duty to plow the snow in the parking lot, the landlord says, I rejected the lease, I'm not going to do that. You can go plow the snow in the parking lot and reduce your rent. But the landlord really doesn't have to do anything. He just has to let you stay in there for the rest of the lease term, and you pay rent. And to the extent, let's say you had a plumbing problem and the landlord didn't fix the plumbing and he was obligated to under the lease, you could get the plumber and then deduct that from the rent too. So, if your landlord files, it's not like you're totally out of luck. Now, in that regard, the landlord may have a mortgagee, and the mortgagee may foreclose and may have the right to terminate your lease, but that's under separate real estate law, which we can talk about, but basically it's not a bankruptcy issue, it's a real estate issue. So a lot of times tenants will try to get subordination and non-disturbance agreements from the mortgage holder, which basically says you recognize that your lease is subordinate to the landlord, but the mortgage holder agrees that as long as you're not in default of the lease, you can stay in the premises even if it forecloses. But that's more of a real estate issue than a bankruptcy issue. Other things you need to worry about in the court are preferences. There was allusion to that previously. The bankruptcy concept is that everybody gets treated equally in accordance with their priority. So obviously a secured creditor is higher priority than an unsecured creditor. And then there are what they have priority claims, like certain taxes are priority claims that get paid before other pre-petition unsecured claims. But let's go back to the example that I was asked about. Let's assume that your family gives you an unsecured loan of $100,000, and it's sitting out there for years and years and years, and then you see that you're going to go bankrupt, and you pay them back the $100,000 because you don't want them to get hurt. So if you make that payment within 90 days of the bankruptcy, then they're going to be subject to suit to have to disgorge that money and put it back in the company because they received more than they otherwise would have in the event of a liquidation. And that's a key point to the preferences too. Not only do you have to be paid within the time period, but you have to receive more than you would in a liquidation. So if the total assets of the business exceed the total liabilities at the end of the day, it's not going to be a preference because the person would have been paid in full in any event. If you're an insider, like if you're repaying yourself a loan that you put in, then they look back a year, not just 90 days. So any payments you got within a year prior to the bankruptcy, they may look back at as a preference if you receive more than you would otherwise. Now, there are defenses. As we said, new value. So if it's a contemporaneous exchange, then there's not going to be a preference. So if you call a supplier and say, I need some PPE, and they send you the PPE and you pay them for the PPE, then it probably is not going to be an antecedent debt because it's a contemporaneous exchange of value. Payments in the ordinary course of business also can be not deemed antecedent debt. So let's assume that you have, you're a grocery store and you buy inventory from somebody and you have 7-day terms and you pay in the 7 days while the value was given 7 days before and was therefore antecedent, is paid in accordance with ordinary business terms, it wouldn't be deemed a preference. It's just really trying to make sure all the money that's paid out of the ordinary course is there for all of the creditors to share and not for somebody to get a benefit from. Also, the court and creditors can seek to set aside fraudulent transfers. And those are transfers made for less than reasonably equivalent value. So, for example, I'm thinking of filing a bankruptcy and the house is in my name and I want to protect my house. And so I transfer it to my wife for $1. My house is worth $500,000. I didn't get reasonably equivalent value, so the asset is gone from the creditors and I didn't get the money for it. They can come into the court and seek to set aside the transfer and have my wife retransfer the property to me so it is available for all creditors. Sometimes you have situations that aren't quite that obvious that, let's say I sold the house to her for $350,000 and she gave me $350,000 in cash. Creditors could still come in and say, listen, it was a $500,000 value. She has to pay another $150 or retransfer it and she'll get, her $350 back when it's sold. So, once again, the concept of all these avoidance powers is to avoid someone getting more than they would be entitled to as against other creditors. Also, offsets. So if, for example, we'll use your bank as an example. Let's assume you owe the bank $100,000 and you have $20,000 in your account and the bank says, you're in default, I'm taking the $20,000. If the bank does that within 90 days of the bankruptcy, it could have to disgorge some of that money. And the test here is, how does the bank compare 90 days ago with the date that it set off the money? So, for example, in my example, the bank took $20,000. Let's assume 90 days before your bankruptcy, you had $2,000 in the bank and you still owed $100,000. So the bank would have improved its position by $18,000 and would be forced to disgorge $18,000 and make it available for all the creditors. So this is, you can see the bank's position was improved by waiting until you got some receivables collected, and the court saying that doesn't work. So back to my initial premise about filing bankruptcy and the cost and the lack of control, sole control, you can see that a lot of these things we've talked about need court approval, and creditors will have the ability to come in, and a trustee, which we'll get to in a second, will have the ability to come in. So you can't necessarily run business as usual here. Chapter 11 is the chapter that most small businesses would use to reorganize. Congress has enacted a new section of the law providing for small businesses, which is defined as clients, companies having debts of less than $2,725,000. The CARES Act increased it to $7,500,000 for 1 year. And you have to be elected to be treated as a small business. And the purpose of the act, which really just became effective this February, it was like they knew that there was going to be a problem come March. But the purpose of the act is to make it less costly and easier for a small business to reorganize. And so we'll go through some of the differences and the benefits of being a small business case. Now, you don't have to elect to be a small business case, but you know, I think that it's not unwise to do so. In a normal Chapter 11 case, there's a creditors committee. Usually 7 of the largest unsecured creditors form a committee. And the committee will have, on all the matters you have to go to court for approval, the committee will be there expressing his opinion and the court will listen to them. The committee can do things like, if you won't, bring suit for preferences and fraudulent conveyances, and they have standing to do so. And guess who pays for their costs and their professionals? You, the company. So, you know, they'll investigate the business to find out if there have been any untoward transactions. They'll be involved in your plan negotiation in all aspects of the case. So it's another hurdle of people you have to deal with, another expense you have to pay. Obviously, it will increase your attorney's expenses too, because he has to deal with them. In a small business case, there are no creditors committees. So it doesn't mean creditors can't come into court, but there's no formed committee and you don't have to deal with them other than a one-on-one basis. In a normal Chapter 11, there'll be a trustee or an examiner can be appointed. A trustee could come in to run the business or investigate business operations. For instance, if creditors think that there's been some fraud and some fraudulent transfers, there could be an examiner to investigate that, and all that you pay for. In a small business case, there's no examiner, and the rights of the trustee are more limited. And not that it doesn't have a say, but it's a much more limited role. When you file a Chapter 11, you then have to file a plan of reorganization. And the code provides that you have to do this within 120 days. And after 120 days, if you have not filed a plan, other parties in interest and creditors committees can file a plan. So if you're thinking you're going to reorganize and you haven't filed something in 120 days, the creditors can come in and say, this case is going nowhere, let's just liquidate it and file a plan to liquidate the company. Most debtors have trouble getting everything together in 120 days, and they can get extensions of that period from the court, and they do routinely. In small business cases, though, they're saying this is a small business. It's not as complex as a Neiman Marcus. File your plan in 90 days. It shouldn't be that much of a trouble. So there's a little shorter time frame, but you avoid other people filing a plan. You just file it, and it should be able to be done in that time frame. In a normal case, before you can put the plan out to a vote for creditors, you have to file a disclosure statement. A disclosure statement, for lack of a better word, is like a SEC offering that you would say if you were buying new stock on the New York Stock Exchange. You go into the history of the company, you have projections, cash flow, you have liquidation analyses, you have business risks and business prospects, and the document can be hundreds of pages long. In a small business case, you don't have to do that. All you have to do is give a brief history, an analysis of what happens if you don't make it to liquidation, projections showing that you can do what you say you want to do under the plan, and agree to put all your future earnings to the trustee to comply with the plan. So it's the contents of a plan in a normal case, much more cumbersome than this. This is, you just basically say, I've been in business for 10 years. We made money until COVID. We haven't had any sales. If we liquidate the business, you're going to get, cents on the dollar for all the tables and chairs I have. But if you let me run the business, business is coming back, and I'm going to be able to make planned payments because I'm going to get the revenues as I did before, and I'll give the money to the trustee so the trustee can pay you. So it's much easier plan to prepare, which is also why the court is limited to the 90 days to give it to you. Now, if you're not in a small business case, confirmation of a plan, meaning the plan being approved and going effective, requires approval of one class of impaired claims. Impaired claims are somebody who you're not paying in accordance with the contract. So, for example, if you're going to pay your unsecured creditors 10 cents on the dollar, they're impaired, and you would need them to approve the claims, approve the plan, or one other class of claims. So there's usually, in coming up with a plan, you can set up different classifications as long as they're reasonable, and you try to always have one class of impaired claims that will sign on. Sometimes it's your bank. You agree that you're going to pay the bank principal and interest, over 5 years rather than 10 years, and the bank says that's fine. Over 10 years rather than 5 years, the bank says that's fine, so they approve, and that's one class which is impaired because it's not being paid in accordance with its contract. You also have to prove that you're not going to follow this by liquidation or further financial reorganization, which again you have to have good cash flows, and you'll probably need some expert testimony from your accountant or some business consultant to show that, yeah, the business can make it, it's likely to make it, and it's not going to be, we're not doing this to come into bankruptcy in another 2 months. Although I'll tell you, there are a lot of cases that get confirmed, and within a year or two, they're back in bankruptcy. Then you need the creditors to accept. So each class, remember we set up different classes, the unsecured creditors, and say landlords in another class, you need 2/3 in amount and half in number to accept. Now this is impaired classes. If you're not impaired, you're deemed to accept the plan. So if you were to say to your bank, I had a 5-year loan at 10% interest, and I'm just going to continue payments on that loan, the bank's not impaired. They don't have to vote. But every other class of creditors, typically the trade where you're trying to give them a haircut, you need 2/3 in amount and at least 50% in number. So if you have $100,000 of claims and that's made up of 10 creditors, you need 67,000 to approve it and at least 5 creditors. And then at the time the plan's approved, you have to pay all your administrative expenses in full. So that means you have to pay, all the attorney's fees, all the landlords for post-petition rent, all of the trade vendors for post-petition rent, and you can negotiate a payment term with them, but at the end of the day, you would have to pay them at confirmation. And if you remember, when we were talking about the leases and the assumption of leases, the reason the creditors don't want them assumed until confirmation is because if you don't get to confirmation, those expenses would be administrative expenses, which would have to be paid before them. And the plan has to allow payment of pre-petition taxes over no more than 5 years. So, presumably we're talking about income taxes here, and you'll space them out, which is fine. If you can't meet all these conditions, you can still force an approval on the creditors through a cram down. Now, a cram down basically has to apply by the absolute priority rule. So for example, if you have a secured creditor, the secured creditor has to be paid not in full confirmation, but it has to receive payments over time that equal the amount of its claim. So for example, if the secured creditor is owed $100,000 and is fully secured, you could pay them over 5 years. You have to pay them interest at a market rate. They'd keep their security, and that would be satisfactory for the court. Unsecured creditors, you cannot, after the secured creditors are paid, the unsecured creditors come next, and you can't have a situation where you retain your equity in the company and the unsecured creditors don't get paid in full unless they would otherwise agree. So this results in oftentimes equity owners putting in new capital. So if you put in new capital, it's like you're buying your equity. And so therefore the creditors, assuming that what you're putting in is a fair value, the creditors can still take a haircut and you can keep the equity because you put in new value. But if your concept is I'm not putting in any more money and I'm not going to pay the creditors in full, but I want to keep all my equity, that's not going to happen without their consent because it violates the absolute priority rule, because you as the equity owner are third in priority and you're getting something for value, i.e. the stock of the company, when the creditors aren't getting paid in full. So that's in your normal case. In a small business case, those administrative claims, you can pay them over time. You don't have to pay them at confirmation. And you can also get the plan confirmed even over objections if it's fair and equitable, meaning you're going to put all of your disposable income for a 3 or 5 year period to make payments to the creditors. And it's likely that you're going to make those payments so you can retain your equity and you don't have to put in more capital to do so. So for small businesses, this is a much better deal. You just basically say, I'm going to give all my earnings, disposable income is after payment of expenses of running the business. So you're basically giving all of your earnings to the creditors over 3 or 5 years, and I'm going to keep ownership of the company. So that's a real good deal compared to what it could be. Good deal is probably an overstatement, but it's better than it could be in a normal case. As a small business debtor, you have to file your last tax returns, balance sheet and cash flow statements when you file, periodic post-petition financial reports, probably monthly, and you have to keep your taxes current, maintain insurance, and meet with creditors periodically. But the whole concept of the small business provisions is to make this quicker, less costly, and easier for a small business to undertake. And as I said, it's new. It only went into effect late February this year. So, there isn't a lot of history about how this is working out, but it'll be interesting to see whether this really does help small businesses undertake a plan, because especially in these times, where businesses are suffering for revenues, I'm not sure, that you're going to be able to successfully reorganize if you don't have the revenues to pay the expenses and to pay some of these old debts. But we'll see. The law was passed in a time that was not unusual like this. So that was a chapter 11, which is usually used for reorganization, can be used for liquidations. Some of the larger, like Circuit City, I was involved in Circuit City, and they liquidated under Chapter 11 because their creditors wouldn't extend them further trade credit, and they couldn't get goods in, but they kept control of the process under Chapter 11. If you're just looking to liquidate your company, I often tell my clients, not to necessarily bother filing a Chapter 7. I mean, if you can liquidate outside of the bankruptcy, it's probably cheaper, and you may or may not do better. But the benefit of the bankruptcy is, the court's going to approve everything. No one's going to be second guessing you. A trustee is appointed to liquidate the assets and to take preference actions, fraudulent conveyance, and then he distributes the proceeds in the order of absolute priority: secured creditors, priority creditors, unsecured creditors, and the like. Basically, you just file your schedules and statement of affairs, which talks about your assets and liabilities. You attend meetings with the creditors, and you leave it all to the trustee to wrap up the business. And in some cases, the trustee can authorize to operate the business. It really doesn't usually do this, but there may be circumstances where it has a bunch of work in process on the manufacturing line, and it wants to convert the work in process, which it views as worth nothing, to finished goods so they can sell them and create a receivable, and they may go ask the court to operate the business so that it can convert the work in process to finished goods. But I didn't deal with Chapter 13, which is an individual bankruptcy. That's a whole different can of worms. Obviously, we didn't have to deal with Chapter 9, which is municipalities. Chapter 12, which deals with farmers. But there are other chapters that apply. But in all these chapters, the basic premises that we discussed at the beginning about court approval for sale of assets, for getting financing, leases and the like, those are generally going to apply to all these cases. So with that, Donna, do we have any questions?
I haven't seen any come through, but certainly I welcome any feedback or from any of the participants. If you have any questions you'd like to have reviewed.
While we're waiting for people to enter questions, I'm going to go ahead and launch our poll.
You want me to answer that, Teresa?
And if the participants could help provide feedback for the webinar, that would be great, and certainly would help us to help you and future attendees. David, do you have any suggestions if folks have more questions at bankruptcy? And I think a lot of times folks are hesitant to hire an attorney for any given issue, but for bankruptcy, clearly it's very complicated. What are your thoughts on that?
I mean, I think that one thing they can do is to reach out to us at SCORE. I and others have some bankruptcy experience, and they could just go to the SCORE website and send us an email or call in and set up an appointment with us, and we can help strategize with them. Obviously, they'll have to get an attorney eventually, and we can give some recommendations of attorneys as well, and go from there. But it's a complicated area to try to figure out by yourself. I mean, your business plan, you can try to figure out, which is, why am I having troubles? Is it because I don't have the revenues? Is it because I'm over leveraged? Is it because I can't get trade support? What are the reasons, and deal with it.
Mm-hmm.
Speaking of that, one way to get trade support sometimes in bankruptcy is you offer the trade creditors, you say, if you give me trade support in this amount of money, then I will give you a lien on some assets so that you're not an unsecured trade support creditor, you're secured, and I know that therefore you've committed to give me the credit and the terms that I want, and you're secured. And sometimes that gets a trade creditor over the hurdle, but you don't want to, depending upon the number of creditors you have, you want a mass of them to be able to give you the credit, unless you have a major supplier who you want to get on board. And in certain circumstances, the courts have even allowed key vendors to be paid on their pre-petition debt as part of the program, so that you can say, give me new credit, I'll give you a lien, and I'll pay you, 10% of my old bills with each new order you give me, or 5% of my old bills or something. The court may allow that too, which could be an inducement. Now, technically, there's questions whether that should be allowed, but courts have allowed it.
I haven't seen any questions yet, so that maybe we'll end a little early. Do you think, or?
Sure. I mean, I'm here for questions, or we can wrap it up. Teresa, do you have all the answers you need?
Yes, the polling's finished, and I do not see any questions either that have been posted. Oh, we have one that just came through chat.
Okay. Do you see it, David?
Let's see. If the company is running out of opportunity of debt, let's just let go of the business. Is it advisable to hire an attorney? I guess the question I'd have on that is, are you personally guaranteeing any of the debt? If you're not personally guaranteeing the debt, it's just and you have a LLC or a corporation, I'm not sure if you know best how to liquidate the business. Now, the question is, are you a retailer selling goods, or are you a service provider providing services? And for instance, if you're a massage therapist, and so you have a bunch of tables and some inventory, lotions that I don't know that you need an attorney to deal with that. If you have inventory, you may be able to dispose of the inventory yourself, either through a sale, or maybe you call a competitor and say, "Do you want to buy my inventory?" Look, I'm an attorney. I always recommend an attorney, but I think that depending upon the amount of assets and your personal situation in terms of whether you're personally liable, you may not need to spend the money on the attorney. In the massage example, you got 4 or 5 tables and some inventory. Whatever you get for that, if you sell it, your attorney's bill is probably going to be more. So, I think it depends on the circumstances. If you have tax issues, I may talk to an attorney because the taxes may follow you. But if it's just trade debt, you could send a nice letter to your trade saying, "Thank you for your support over all the years. Unfortunately, due to XYZ, I'm unable to continue my business, and love and kisses." Now, the other thing to remember is your trade can also file a bankruptcy against you. So if you have more than 12 creditors, 3 of them can get together as long as they owe more than $15,000 and change, and file an involuntary liquidation. If there's less than 12, any one creditor having more than 15,000 could do so. So you may not be out of the woods there. They may just want the finality of having a court supervised liquidation. But once again, if they file a Chapter 7, you just have to go to meetings and let the trustee take over and deal with it. So
David, would it be okay if I put your SCORE email into the chat for people that have additional questions and would like to reach out to you?
Okay.
Can I put that in there?
Sure.
Okay.
One thing that I always find interesting that folks might not have an understanding of, when you're underwater, you have all these creditors. How do you secure funds to hire a bankruptcy attorney? Like, what is that process?
Well, sometimes if you have a line of credit, you borrow the money from the bank. If you don't have a line of credit, you try to manage your cash flow to pay the attorney, or it may be that you have to personally, put the money in. But if it were me, managing cash flow in times of crisis is crucial. One thing that I found when we talked about restructurings a lot is that people are generally honest and want to pay their bills, and what you need to do is stretch the trade some more and use the cash coming in to pay for your attorney. It's not the nicest thing to do, but at the same time, if your trade terms is 30 days and you're having trouble, you don't pay them in 30 days. You hoard your cash and stretch them out as far as you can go and use the cash to hire your attorney to do what you need to have them do. You know, a lot of cases, a lot of the larger cases I was involved in, like Circuit City, they would just borrow from the bank, you know, but we were talking, you know, millions of dollars they borrow from their attorneys. And,
Wow.
you know, we're not talking small business cases, but here, you know, I think, and I talked to a client the other day, and that was the question: do you have money to? He says, we can scrape it together. We'll find a way to scrape it together. You know, in other words, so won't pay the landlord. They won't pay some trade. They'll find a way to scrape it together.
All right. Thank you. Any other questions from the attendees?
I do not see any.
Oh,
Oh, wait.
Yeah.
All right, if your business fails and non-personally guaranteed debt is not paid, how does that affect a potential new business? I guess there are a couple of answers to that. If the new business is the same business, so in other words, you're a massage therapist, just use that example, and you're just saying, all right, this business is dead, so I'm going to liquidate ABC Massage and open up as XYZ Massage, and you leave your creditors holding the bag. You may have to find a new source of creditors, and in a very close community of creditors, if there is a close community, word may get out that you stiff them and whatever. And similarly, on a credit report, when they do a credit report on you, it may show that your business failed as well. My experience, though, amazingly enough, is that creditors like to make sales. So, you know, we've had cases where the company went into Chapter 11 and owed the creditors a significant amount for those creditors. And the creditors said, all right, in Chapter 11, I'll still sell you because I know I have administrative priority. And so I think in some ways, depending upon the nature of your business and the creditors may continue to do business with you. If it's a totally new business, you probably have a different set of creditors. And the only question would be is if any of them did a credit report on you, it may show up that you had a failed business. But you know, if it's not guaranteed by you, it really shouldn't affect your personal credit. And you know, you can always explain why your old business failed. So I think it depends on the circumstances. In most cases, I think you can get away with it. So you know, I was talking to a restaurant owner the other day, and they're thinking of just closing up the restaurant, but they have another restaurant, and, you know, that they were thinking of opening. And I said, well, just form a new entity and we'll open it. And you know, they were confident they could get, you know, inventory, and that's what they were going to do. So it doesn't necessarily mean the end of your business career.
Well, I don't see anything new, so I guess we can go ahead and end this webinar. And we did give David's email if you have additional questions, or you can reach out to any of the SCORE chapters that you may belong to, and reach out to a counselor there as well.
Great. Thank you, Teresa. Thank you very much for your presentation, David.
Thank you, Don and Teresa. Appreciate it.
Thank you.